tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And we got one for you. Here's one we prepared earlier. David Whiting, well-known Melbourne solicitor, here to hand out some free legal advice. Hello, David.
Hello, Virginia.
Homework for us today?
Yes, we did. Sarah from Camberwell was going for a bike ride on a bike path with her partner, and he slipped and he fell and has some bruising and some teeth damage and some other bits and pieces. And the question was, is there a claim? And the short answer is only if there is evidence that the person who manages the bike path did something wrong. And having listened to the call again, there's nothing that indicates that.
Well, there was just to jump in. There was a suggestion by our caller that perhaps they were midway through doing some kind of construction or work and had maybe left something behind that he had tripped on. There was a bit of rubble or something that had a spray mark on it. So I think she was
a piece of concrete.
Yeah, she was concluding that maybe the building work had been left behind in a dangerous way.
If he had fallen as a result of that, then whoever manages the bike path, which I imagine will either be Melbourne Parks or the council, would have some responsibility. I was interested in whether or not the Transport Accident Act had any impact, and the answer is it doesn't, because to be covered by the Transport Accident Act, the accident needs to be caused directly by the driving of a motor vehicle or a motor car or a train or a tram. So bicycles at that level, can't be helped. So it's a fault-based compensation system.
Yeah,
it's interesting. New Zealand has a fault-free compensation system. We have fault-free for motor vehicle accidents and work cover, but apart from that, fault is an important part of our compensation.
So as a pedestrian, if I was walking along and some bits of the pedestrian work that they were doing, the council was doing a few days ago, were dangerously left behind and I tripped, would I have an action?
Yes.
So why can't the bike rider make the same case if they can establish the bits
Well, they can, but it's a fault-based system.
Yes.
They need to prove that whoever was responsible for it, yes. Right? Whereas under you would go back and you would take some pictures, you would try and find out, the council, whoever's doing it, will have work records as to work they were doing and the work they're planning, and that's recoverable under freedom of information. But you might find that you'd get somewhere if you wrote the letter of demand and say, I've suffered these injuries, I need some compensation, please.
Well, let's stay in that theme with our first call this morning. It comes from Damien in Hurstbridge about fault and responsibility and then blame. Damien, what's the story? Hi.
Good morning, Virginia and David. During the last couple of weeks, when the rain, we've had a lot of rain, so the creeks have come right up, and a lot of the teenage kids are itching to get out, so they've all come to our side of the creek. The creek denotes the boundary of our property, so they swim across the boundary to the higher cliff sides and jump off that into the creek. It's pretty dangerous, but it's what kids do, I suppose. Kids of all ages. If they were to slip climbing up the cliff, or if they hurt themselves jumping off our side of the creek, are we liable for that?
No. But you would be liable if you decided, for example, that you would put in a platform for them to jump from.
Oh, so no rope swing. All right, I'll cross that off the list.
Okay. Thank you very much. The issue will be, have you facilitated the problem, and at which stage you might have some contribution. You would also probably find that your title stops some distance up on the bank, even though you'll have a piece of paper which would indicate that your title might be, for example, the midpoint of the creek or the river. You'll actually find that the Property Law Act now means that your the land you actually own is set back from the bank of the creek. So it won't be yours, but whatever you do, don't facilitate the doing of an action which might cause a problem.
Damien, are those kids at any point in their travels to get to the creek, are they on your property?
Yeah, well, they climb up the cliff and then they come into the paddock a bit to make it a bit easier, and then back over to the creek. But the Section 32 says creek denotes the boundary.
Oh, it will, because you will have had what's called a riparian title.
Good word.
But what you'll find is that the state has taken back the bit of the top of the bank next to your property.
Okay, well, in that case, I don't know if they're coming onto our property because I won't know where it sort of stops and,
Because they could,
but even
if
if
they
they
came to
do,
grief on
Damien,
some part of the property, though, David, what if they did?
Well, if he slips because he keeps his grass too long, I'm not worried about those. You'll have a public liability cover in anyway, Damien, on your property. So I'm not worried about it. I'm only worried in circumstances where you take some action that facilitates dangerous contact.
Okay, well, there you are. That's reasonably clear. Damien, good luck. And I hope the kids don't get into trouble there. Rennie in Sunbury, what are you up to?
Yes, good morning. Thank you very much for this call. I'm in the procedure of making out my will because I've had different ones asked to me to, have you made your will out? Have you made your will out? Mm-hmm. Now I'm scribing it down on A4 paper.
Rennie, are they people who are optimistically hopeful, or are they just want to make sure you're looked after properly?
Yes, want to make sure.
Good.
Okay.
Yeah,
Rennie, here's the deal. You can write your own will. If you write it longhand, it's called a holographic will. Now, the only requirement for formal validity of a will is that it be signed by the will maker, and that's you, at the foot or end of it, and it be witnessed by two witnesses who sign in the sight and sight of each other.
So they do it together.
It's possible. So it's significantly better if the three of you get together, you all share the same pen, and you sign one after the other, and you sign at the end. Yes. If it's multiple pages, then you should number the pages and initial the pages.
Yes.
And you should date the last page. And the last thing you should do is make sure that it's kept in a safe place.
Now, I do not have to turn and take it to a solicitor to get verified?
No, you don't.
Thank you very, very much, sir.
Rennie, I hope that no one has cause to look at this document for quite some time.
Neither do I.
Are you in good health, Rennie?
Pardon?
Are you in good health?
Yes, I'm in reasonably good health, apart from a bit of a bloody head cold and tap running like a water tap.
Well, that sounds like a bit of hay fever too, hopefully only. Rennie, good to hear from you. Good luck, and I hope that works for you. Mark in Warrnambool, how can we help? Good morning.
Oh, hi. I entered into an agreement with a telephone listing company, and there was a problem with location, as in where people could contact me from, and I asked them to fix it, and I said, can we forward date the arrangement so that when it's fixed, I've still got 6 months? And they refused. They just won't get back to me, and they keep invoicing me.
So Mark, you've entered into a contract for someone, presumably to run a print ad for you.
A telephone ad, yeah, online. Yeah.
And so it's an online telephone ad, and there's some kind of geo-fencing so that it's only visible to people from a particular area.
Yeah, that's correct. The plan? Yeah, that's it.
Okay. Then the answer would be you could, if you wanted to go to VCAT to say, well, how much should I now pay in this particular circumstance? So you might say, let's say, for example, I'm sorry?
Then I would have to pay them as well, yeah?
You'd need to pay VCAT, yes, you'd need to pay an application fee, but your application comes along and what you're saying is, I contracted for an ad to appear to viewers in this particular location, and it didn't for this you. So I think what you ought to do is ask them, are they going to extend the expiry date of the advertisement?
That's right. Yeah, that's the question, yeah.
Yes.
That was what I was hoping to do, yeah.
Okay.
And if the answer to that is yes, then I would be paying them because it's going to be easier than... It's going to be less expensive in terms of money and time.
I'm more than happy to pay it. I wanted the advertising, but I just can't get them to get back to me on
it. Well, then you might go the VCAT route and start the negotiation at that point.
Okay.
All right. Good luck.
Yeah. Cheers.
I hope that works. Paul in Thornbury, what's going on?
Yeah, g'day. A sibling and I are executors of a will. There's a third sibling who we've not been able to get in contact with. Mm-hmm. Just wanting to know what do we do with their, I guess, their portion.
Mm-hmm.
So it's their share of the estate?
Their share of the estate, certainly. We want to make sure that, you know, presumably we will get in contact with them eventually. They're just unavailable and have been for about 3 years. So what's the expectations?
I'll give you two answers, Mark. Estate trustees used to have a department that's sole job was to go and find people like your beneficiary, and they charged a fee for it. Now, as a result of will changes, I'm fairly sure that not so many people get that done anymore, but you might call state trustees and see if they still offer that service. The cost of finding that person would be paid from that person's share of the estate. The other thing that you need to do, and you might do them at pretty much the same time, is that there is a document, there's a legislation in Victoria relating to unclaimed monies. And I think it's the Unclaimed Monies Act. And if you are holding money that belongs to somebody else and they don't claim, so it's unclaimed lottery prizes, share dividends that are not cleared, cheques that are never presented, that money goes to the state and is held by the state, or in some cases the Commonwealth, for a period of time.
But are we able to invest it? Because I'm not trying to get them out of their share, and we're just...
No, if it goes to the state, the money comes back. So I would set yourself a time frame to find this person. And if you can't find the person in that time, then you have obligations to dispose of the money, to give it to the state of Victoria using the Unclaimed Monies Act.
Okay. Have you tried very extensively to find your sibling, Paul?
Not extensively.
There's a few more calls you could still make?
Oh, there are certain actions we could probably do. Certainly not wanting to scout them out of their entitlements. I guess it's just that in the preceding 4 years there's been no contact.
Sure.
So,
but is there is there an obligation on executors, David, to really do all that they can to find this person?
Well, one of the... in Paul and making an application to be appointed an executor, he promised to duly and faithfully execute the will. And to me, that means locate the beneficiary and pay the money. So you have an obligation to do that, Paul. If the administration of the estate is otherwise complete, it would be reasonable to apply some of the money going to this person to finding them.
Yeah. If the usual
I think you've got to do it, Paul.
Yeah.
Oh, yeah, no, happy to do it, but I was just wondering whether we could possibly, invest the money on their behalf in the interim rather than just sort of have it sitting there with the state government.
Well, it's going to be invested at 0.1 or 0.2%, and it's going to probably, given unless you've got a tax file number for the estate, put the money in. How much are we talking about, Paul?
Oh, a couple of 100,000.
Then let's be really nice to them and let's see if we can find them rather than mind it.
Yeah. And social media is your friend. It's very, very hard for most people to absolutely go completely missing given the extent of social media these days. So good luck with a few judicious phone calls and a bit of elbow grease and work. You should at least be able to pick up a thread, I would imagine. David, do a lot of people just go completely missing, like impossible to find in your experience? David?
No, very few. Very, very few. You can almost always find someone if you're prepared to spend a little money and put a little bit of time in.
All right, let's hear from Rose in Glen Waverley. What's going on, Rose?
Oh, hi. Look, I live in a lovely street in Glen Waverley, and our street and a number of streets around us have a covenant on there that says you can't build front fences and you can't build side fences more than 3 metres away from the homes. And we've had some new properties being built in our street, and those properties have been asked to pull down those fences when they've built them because the builder hasn't looked at the the code, the covenant.
Yep.
And but those fences have usually been made out of timber, and even a brick front fence was asked to be removed. Now we've got another property that has built colour bond fences up to the pavement, and the council has said we can't do anything about it. I've rung the planning minister. Oh, we can't do anything about it, and since then another property now has built another fence, which is a colour bond fence.
Rose.
And yes.
Rose, here's the way it works, right? As a general principle, to build a fence under 900 mil on the front boundary of your property does not require a permit from the council. So it's not a council planning issue. When the properties were sold, the developer required from the purchasers and those who then owned the property that they wouldn't build a fence within a particular distance of the front boundary. Now, the right to enforce that restrictive covenant will generally be every other lot in the subdivision.
Yes.
So the right to enforce it will, if you are stuck with the burden of the covenant, Rose, then it's also likely that you have the benefits of the covenant.
Look, I've made inquiries and I've rung the planning minister's office. What I've been told is that because now the house next door has been sold and that's going to be torn down, and I don't want fences between us. But what I don't understand is that I've been told that either the developer, and these it's over 50 years ago, would have to put in the complaint, or we have to seek legal advice. Myself and other neighbours have to get legal advice, which we have to pay for. What I don't understand is if you have to apply to the Supreme Court to have that covenant removed, then who is, even under neighbourhood character, surely something should be in place.
No, the planning laws require there is a exemption in the planning schemes and the planning rules relating to front fences below a particular height. So it's not a state government requirement, it's a contractual requirement that the people who built the house that you now live in agreed to at the time the property was acquired. So it's a contractual right between individuals. It is not it's not a rule imposed by the state, and so the state will not require. The state's not the person you ask permission from. But on the other hand, Rose, if there was a restrictive covenant that said, for example, it needed to be only one house could be built on the land, then and you went and applied to the council to put into townhouses, then there's a provision in the planning scheme and in the Planning and Environment Act that says, in essence, if there is a restrictive covenant that prohibits this kind of behaviour and you want our permission to do that thing, then we must say no.
Okay.
Right, so in order for council to get involved, it needs to be something the planning scheme requires them to do, not the contract between previous owners.
So you'll need to look at the scheme, I guess. Good luck with that, Rose. Ali in Cranbourne West, how can we help?
Good morning, guys. Thanks for taking my call. I've got a younger brother. He's been up to no good. He was walking around the park around where we live, and he found a wallet just out on the road. So he decided, him and his mate, to go and spend a bit of money, around $400 from the credit card, someone else's credit card. Eventually, the CCTV captured him when they pulled over to spend the money outside the shop. Mm-hmm. So the police has charged him, and I only got involved after he got charged and he got a call letter. And I took him to the defendant's house and to apologize and return the wallet and whatever they found, and offered to pay the money back. Mm-hmm. The defendant was a very generous man, and he made a mistake, young fella, and he said he will call the police to drop the charge and also write a letter. What's the chance of the police dropping the charge? I just wanted to find out, give my information.
You've watched too much American television, Ali, the charge belongs to the police and not to the neighbour. You want to do what needs to happen is two things. The person whose credit card was stolen needs, and has the money been paid back?
We offered to pay the money back, but the defendant said he's received the money from the bank already, a compensation from the bank for lost card.
Well then I understand that, but at the moment somebody is entitled to the money back. Now, whether that's the bank or your neighbour, it sounds like it's the bank. So your neighbours reported them as inappropriate transactions. They've been reversed, but the retailer's still out of pocket.
Yes. So
there needs to be... Well, it requires... so that you've got to talk to the police about how you might restore everybody to the position they were in. Yep. And what you then do is you talk to the informant about something called a diversion program.
Yep.
Where effectively your younger brother writes a letter of apology. It requires the informant, that's the police officer, to agree. Your brother apologises, he writes the appropriate letters of apology, and effectively in 12 months' time, if he doesn't come to the attention of the law, the charge will just disappear.
Yep.
So have a look on the net for diversion program and talk to the informant, who's the police officer, about how the bank might get their money back.
Ali, I hope that works. It sounds like everyone's trying to be reasonable with some foolishness that, of course, needs to be acknowledged. But it's a better response than everyone sort of, going the hack with taking people to court then, isn't it, David?
Look, let's just regard it as being a foolish mistake that's been caught early and isn't likely to reoccur. That's what the diversion program's about. It's a refinement of the good behaviour bond.
Let's quickly hear from Lynn in Frankston South. Lynn, I think we can fit you in just before we talk finance. What's going on? Hello.
Thank you. Good morning, David and Virginia. It's regarding my mother's will. She's still living, has 4 children, 2 executors and 2 financial power of attorneys, her children that are on the will. One of those people, my sibling, has been diagnosed with early onset dementia, and I just wondered legally where we stand with them being valid on the will and the power of attorney responsibilities.
Right. Lynn, can you tell me, are the attorneys joint and several, or are they joint?
Joint.
So everything requires both of them?
Yes.
Then effectively you've got a power of attorney which isn't going to work.
Right.
So what you would, let's forget the will for the moment. The one with dementia would simply not apply for a grant of probate at the time. But what would happen is you should logically make an application to VCAT for a partial revocation of the power of attorney on the basis of the sister with dementia not being able to act.
Right. Okay, terrific. Thank you very much.
Okay.
Sure.
Well, I hope that's helpful. David, always good to have you on board. Thank you so much for all that help.
Thanks, Virginia.
We'll talk next week. David Whiting there, well-known Melbourne solicitor.